Is there anyone here on data protection today, or?
Yes, of course, James. Please go ahead.
Okay, so the European Court decided this morning, much to everyone's amazement, that there already is a right to be forgotten in Europe. But meanwhile, Viviane Reding and the Commission have been working on a right to be forgotten for the last 2 years. So my question very specifically is, oh, hi, Mina. Do we still need to, does the Commission still believe that we need to introduce a right to be forgotten after the court found one this morning? Thanks.
Thanks, James, for drawing attention to this important and good ruling for the protection of personal data in Europe. Well, the rules on which the court ruled date back to 1995, which means pretty much pre-internet age. So therefore, we need to clarify how the right to be forgotten applies in the online world. And this is very much done by the proposal for a data protection reform that the Commission put forward in January 2012. It clarifies it in 2 aspects. First of all, it says very clearly that European data protection rules apply to non-European companies whenever they offer their services to consumers on the European market. So also the right to be forgotten would then apply, which in these rules is not very clear, that because today the only link that is required for EU law to bite is the presence of a physical server in one of the member states. This is at least how certain companies are arguing, but in future it will be clear. And secondly, we're clarifying that the right to be forgotten, the burden of proof, so the right to be forgotten applies, you want to have your data deleted, well, only if they're no longer necessary. Today, it's up for the consumers to prove this. Well, this is not very easy and effective. Well, in future, we have reversed the burden of proof, and it will be for companies to prove if the data is needed. Secondly, there is another important update. The right to be forgotten will also apply to third parties, so whenever the data has been disseminated further by these parties, there will be an obligation for them to take reasonable steps to have these data deleted. The European Parliament wants to go even further. It has suggested an obligation for the delete to third parties, and this is all inscribed in the data protection regulation, which was already backed by the European Parliament in March.
Okay, thank you. Still on this, I'll just hand over to Jonathan while I go off to the Ukraine meeting, and I'll see you later at the press conference. But Jonathan will take over from.
Yeah, so there's a further question down here. Go ahead.
Apart from the legal analysis, I would like to ask you for a political comment about the rule today in the court. Is this a good rule for the European Commission?
Indeed, the ruling is good news because it confirms the position of the European Commission. First, that European law can apply to a search engine and that Google is a controller of data, can be regarded as a controller. And this is the position that the Commission has taken in this case. This is also the position that we have taken in the European Data Protection Reform. So it's above all not good only for the Commission, but for citizens who will see their data better protected.